Legal 116. You've completed the orientation, I'm sure, so you've already had an introduction to me and the course expectations as a general rule. So I'll get right into what we're supposed to be covering for the rest of this week and the other part of your assignment for week 1. For this week, you have a few goals and some expectations for grasping the things that are laid out. What I'm looking for is that you're able to define litigation, to distinguish between criminal and civil litigation, to describe the structure of a typical court system, explain the function of intermediate appellate courts, differentiate subject matter jurisdiction from personal jurisdiction, have a good idea about what's meant by venue. You should know the difference between procedural rules and substantive law, and the difference between legal remedies and equitable remedies. Now, I'm going to go through those things, but you need to work to grasp these things. For this course, it becomes about language, the language that you're going to need to learn and know and understand to be able to navigate the civil court system. So litigation is a process by which disputes of opposing parties are administered by a neutral third party. And that neutral third party has the power to render a resolution of a dispute binding upon the two disputants. And civil litigation is a process by which the disputes of opposing parties are administered in a non-criminal setting by a neutral third party, a judge. And the dispute centers upon the determination of the bounds of certain alleged rights, privileges, or obligations. Criminal law focuses on the rights of society, of the public. It seeks to regulate conduct, and it punishes. Civil law seeks to protect the rights of individuals, and it seeks to compensate or to protect those rights in a non-punishing way. Now, where does this happen? It happens in the courthouse. And at the courthouse, if you've been to, say, the Peoria County Courthouse or the Tazewell County Courthouse, there's multiple courtrooms. Some of those courtrooms are civil courtrooms. They hear civil cases. In the Peoria County Courthouse, there's a couple courtrooms that handle the major cases, the cases over a certain amount of money, the high-dollar cases. There's a courtroom that handles the middle ground cases, and maybe two, and a small claims court. Now, if you've had family law, and if you haven't, you will in the spring, family law is civil litigation, but it's handled in a couple different courts. When I talk about subject matter jurisdiction, I'm referring to the court's ability to hear or preside over a certain type of case. And what I just described to you, the different courtrooms that exist in the Peoria County Courthouse, they divide those cases up so certain cases are only held in certain courtrooms by and heard by certain judges. Those state courts have the ability to hear that type of case by statute. If you've had legal research, or if you're in legal research right now, you know or will know that there's certain questions we ask ourselves when we're trying to figure out jurisdiction, and then the other term I'm going to talk about in a minute, venue. One of the first is we ask if it's a state or federal law issue. Now, the only way we know that is we have to identify what area of the law it's coming from, and look to see if there is a statute that regulates that particular area of law. Before we get there, we might ask, is it civil or criminal? Is it civil or criminal? Again, not always an easy thing to determine, but at the end of your journey in the law, you'll understand what is criminal and what is not criminal law, what is civil law and what is not civil law, and you can always look at what the focus is of the issue to determine whether it's a crime that was committed or a civil wrong that was committed. In addition to subject matter jurisdiction, a court has to have personal jurisdiction over a particular party. They have to be able to compel somebody to come to court. The court must have both subject matter jurisdiction, the authority to hear and decide that type of case, and the ability to exercise jurisdiction over the parties, personal jurisdiction, in the same case, jurisdiction to be able to compel that individual to come to court. Now, the related concept of venue, as it's related to our courts, is a geographic one, and I suggest that you think of venue geographically with a map of the state or the jurisdiction you're in your mind. Or pull out the map, and most courts have a map that lists jurisdictions. So based on where you reside or where the case occurred, a particular court would have jurisdiction over that particular area. Venue's geographic in nature. And you either learn this in legal research or you'll learn it this semester in legal research. But the state and federal court systems are divided up geographically, and they have defined boundaries. And just as a court has to have subject matter jurisdiction and personal jurisdiction to hear a case, the plaintiff must file a case in the proper venue. As an example, in all of our courses we discuss where you must file different types of cases. A divorce case, as an example, has distinct possibilities, more than one choice potentially, depending on the status or the domicile of the parties at the time the case or the divorce is filed. Venue for a personal injury case is typically limited to the county or location of the court where the accident or incident occurred. And the last language that you really need to memorize as you develop this new legal language is procedural and substantive law. And some of you know from having me in other courses, this is easiest to remember if you think of procedure as being the how, procedural law being the how we do something, and substantive law being the what. Now, typically, the how we do something, the procedural law, is dictated by court rules. In Illinois, we have Illinois Supreme Court rules, we have local court rules, and we have a statute known as the Code of Civil Procedure. And that provides the how we do certain things. The Code of Civil Procedure also provides the what. It defines what a complaint is, what discovery is, and then adds guidance in the form of parameters for those things. Those of you who had my criminal law course or my 227 or 230 course will remember that this is analogous to our criminal statutes that defined Illinois criminal acts like battery, robbery, etc., and the Code of Criminal Procedure that guides us as to expectations for how criminal cases will proceed or how an arrest may be made, etc. Depending on the facts of the case, the applicable statutes, or the common law that facilitates a particular claim, jurisdiction and venue, you're going to then determine what the legal remedies are. And for an Illinois criminal case, these are the possibilities. We can have money damages, damages expressed in dollars and cents. Compensatory damages, which are typically money damages awarded to a party who's proven that the other side's at fault and the damages were sustained. These damages are designed to place the party receiving the damages in as good a position as he or she would have been in if the wrong had not taken place. Now, one of the realities we'll talk about in later weeks is that most of our clients are never fully compensated. If you lose the use of part of your body or have some sort of physical injury, no amount of money is going to make you what you were before. Special damages are compensatory damages which are precisely calculable. They're evidenced by bills or invoices, your medical bills, as an example. Those are special damages. You're seeking to be compensated for those out-of-pocket expenses that are evidenced by documents, your medical bills. General damages, compensatory damages which are not capable of precise calculations but must be estimated. And that's pain and suffering, the future of disability. If you have, many of you may have experienced it, or maybe you're not, but I'm old, so I do. I have injuries that I sustained long ago that seem to creep up as I get older in different ways. If I was compensated for one of those injuries long ago, it probably wouldn't be worth the pain and suffering, or probably didn't compensate me enough for the pain and suffering today. So general damages are largely speculative. There's not a precise calculation, and we'll get into that in later weeks, but that's what we see for pain and suffering and future disability. There is an opportunity for punitive damages in a limited number of cases, and we'll get into that as well later, but they're designed to punish the wrongdoer, and so we discourage punitive damages in our laws. You really have to work to be able to get a case where there's punitive damages that are involved, and when punitive damages are allowed, the wrongful behavior is pretty severe, or it's essentially that somebody has put other people at risks knowing that there was that risk. Now, there are equitable remedies that we need to talk about, and those are applicable where money or compensatory damages won't suffice. A lot of times they're dealt with in contract cases, civil disputes over a contract. Now, an injunction directs a party to perform a certain act or to stop doing something. And then another that you should be aware of, specific for performance, it requires a breaching party to perform the obligations of a contract specifically. Generally requires that the object of the contract is unique and that it forces the contract to be performed. An injunction can operate with land. You could have a neighbor who's doing something that damages your land or potentially damages your land, and the court could issue an injunction telling them to stop that behavior, as an example. For this week, I want you to work to get these terms down. I want you to develop this language. It will serve you well in the coming weeks. It will serve you even better in your career, but you have to work to get this language. So work on those terms. Work on those things that I outlined. Read what I asked you to read, and just start working on developing that language, committing those those terms and those concepts to memory so you understand, the court system. So you understand what is meant by venue when you hear that word, that you are able to distinguish between procedural and substantive law, that you're able to distinguish between legal and equitable remedies, subject matter and personal jurisdiction. You understand how those two go together. You need to be able to do all of those things. The work you put in this week is going to help you tremendously as we get deeper into the woods on each of those things. That's what I have for week 1. If you need me, you know where to find me.